Welcome to Fire Department Billing for Ambulance Services. This is our third module in the 7-module lecture series. My name is Brad Pinsky, and we are here again on Pinsky Law Presents, and this module is about waiving and assuming copayments. Is it a federal felony? So many of you like to use the term soft billing. That sends just shockwaves down my spine. Why? Because soft billing generally is a federal felony. You cannot waive, just waive copayments. Let me explain the point of copayment so that you understand this. Copayments are designed so that a person who is not in need of ambulance or other medical services is deterred, for lack of better words, from going to the hospital or using those services, again, when they don't need them. But they're not set high enough where they would deter a legitimate patient. So Medicare uses a $35 or $50 copayment, out-of-pocket copayment, to deter unnecessary patients, unnecessary use of services. But again, they're not set so high that they would deter a regular patient who's in, a better word is an emergent patient, somebody who really needs these services. So let's talk today because many of you want to waive or not collect the copayments. Now, we've got to be very clear. Copayments are not deductibles. Copayments are different than deductibles, right? A copayment is something that a patient pays as their portion of the total bill. Now, later in modules, we're going to talk about balance billing as we go through the rules that really explain, and that's the next module, the rules that explain all about the actual bills themselves, and we'll talk about the balance billing prohibition. Copayments are part of the approved bill, but they're the out-of-pocket portion. Now, that's different than a deductible slightly. One is because the purpose of a deductible is not to deter you from using the services. The insurance companies there just say, listen, you chose to pay this amount, and if you pay a lower amount for insurance, then if you're going to use it, then the risk you take is you're going to have to start using your deductible up. In other words, a deductible is where the insurance company says to you, we may pay certain amounts, but before we do, you have to use up your deductible. And usually the deductible is a quid pro quo for a lower insurance bill. With higher insurance bills, more expensive plans, you have no or low deductibles, okay? But that's not what we're talking about, though we do want to talk about it. You can't waive deductibles. There's just no way to do that. But what we can do is talk about copayments and waiving or assuming copayments. So let's start here. This is only about 7 slides. This is a very complicated topic, but it's one that we can address with you more on a one-on-one. But I'm going to give you the most common scenarios as we go through this. So again, let's say that federal law requires a real effort to collect copayments. You cannot stand up in a meeting and tell everybody, hey, members of the public, we're going to soft bill or insurance only bill, because if you do that, you're announcing that you may be committing a federal felony. Maybe, because as we're going to talk, there are legal ways for some entities to waive or assume copayments. So please don't stand up until we're ready, until we've got the program in place to say, hey, we're going to do insurance only, because not everybody can do that. There are options available to those services that don't want to collect the copayment. Again, this module. So now this is in addition to, let's call it hardship cases. Remember that many of you as not-for-profit corporations are charitable corporations. The fire department, if you're a 501c3, maybe a C4, but you really want to be a C3 here. And if you're not, totally different topic, but we really want to convert you. But as a C3, you're a charitable entity. As a not-for-profit corporation, you're a charitable entity as well at the state law level. The 501c3 is a federal tax exempt level. But as a not-for-profit corporation, you may exist to provide charitable services. What does that mean? That means that financial hardship may be an excuse for inability to pay all or some of the copayment. Now, again, the copayments we're talking are like $35 to $50, but I'm very aware that especially some elderly may be only living on Social Security or a very limited pension or very little savings, if any. So it may be important to take financial hardships cases, and for that, you're going to want to have a charity care policy, which is something we can draft for you. But charity care policies is not waiving copayments, although that may be a way to forgive the copayment. Let's talk about the two ways to legally avoid collecting the copayments. So there's two methods, and we've laid them out here for you. So method one, this is where, and these facts are very important, this is where a municipality, not a private, not-for-profit, a municipality, which includes a fire district, that owns the ambulance service, and again, not contracts for ambulance service, but owns the ambulance service. So the municipality that owns an ambulance service, by federal law, can waive copayments for its own service, for its own residents, right? The residents of the municipality. This is allowed, but let me make clear what's not allowed. If you're not a municipality, this is not allowed. And if the municipality contracts for ambulance service, then it also may not waive copayments. Method one. Now, method two, we're going to talk about another method under the contracting scenario. But let's start with this. So the municipality owns the ambulance service. It's its own ambulance service. Now, this is pretty easy to do when it's a town, a village, or a city, or the county contracts with an ambulance company and owns the CON, holds the ambulance service certificate in the municipality's name. This is harder when there's a contractual relationship, though, again, method two may solve that. But again, this is if the municipality owns the ambulance service. The problem is this gets extremely complicated with a fire district whose fire company or squad owns the ambulance service certificate. Now, the question here is, does the municipality own the ambulance service, or does it contract with an ambulance service when the emergency rescue and first aid squad, in other words, the ambulance company, but I use the term emergency rescue and first aid squad because that's how it's referred to in General Municipal Law 209B, and that's what allows for billing, if you haven't caught that yet. So this is more complicated because the fire district, which contracts, remember that's the big no-no, which contracts with its squad and doesn't own the ambulance service certificate, in other words, the squad owns the ambulance service certificate, it raises the question, well, is this the municipality, the fire district's own ambulance service? I would argue it is not. I would argue that if the fire district owns the ambulance service certificate and uses the services of its own fire department, whether that's separately incorporated or not, that would fall within this method that allows waiving copayments. However, I am pretty confident that if the fire district does not own the ambulance service certificate and then has an arrangement with its fire company or emergency squad to provide ambulance services, and the ambulance service certificate is in the name of the fire department, Inc., the corporation, or the squad, Inc., right, the corporation, that is not going to be allowed. You can't waive copayments. So you may want to consider, for this reason, transferring the ambulance service certificate back to the fire district. Or maybe the fire district wants to get its own municipal ambulance service certificate, which it can do. It's a process, but it's automatically granted it for 2 years. So if you want the fire district to be able to waive copayments, we have to have the ambulance service certificate in the fire district's name under this method. Now, there's another method. Method number two. Now, this is where the municipality, which contracts with another ambulance service, here, the municipality can assume the copayment obligation. Here, no resident would pay for co-payments, just the same. The residents still pay for deductibles, as we talked about and we'll talk more about. But let me explain what this is. Assuming co-payment obligations is very different than waiving co-payment obligations, right? So a municipality that waives them just says, listen, they're ours and we're going to waive them. The municipality that assumes them is saying, listen, contracted ambulance service, in this case, the emergency squad or fire department corporation, you're going to get paid a certain amount of money. Let's call it $100,000. We're going to give you $100,000 to provide ambulance services. And as part of that $100,000, we're going to make a reasonable attempt to estimate the co-payments that we're supposed to collect from Medicare, Medicaid, and other government insurers. And that's not too hard. I normally say, listen, probably 60% of your claims are Medicare. We'll know more after we do this for a couple of years. And, the average copayment is maximum of $50. So we'll take 60% of your calls, whatever that is, multiply it by $50. And of that $100,000 payment, we're going to allocate that portion, again, $50 times 60% of your calls, and we're going to say that is the amount of the copayment. And we, the municipality, since we already collected that in taxes from our residents, and since we owe you money, fire department, we're going to assume the copayment obligation by using part of that tax money to pay for copayments. See, we're not waiving it. It's just that the government entity, in this case probably the fire district, is going to assume that obligation and use the tax money to pay for the copayments. Now, that's all great when we have a town that contracts with a ambulance service or a village that contracts with an ambulance service. The problem is fire districts do not typically pay the fire department money to serve the fire districts. Now, we know that the law from the first two modules, the law requires that there be a contract between the ambulance service and the authority having jurisdiction, the authority in control. In this case, let's say the fire district. So the fire district certainly must have a contract in place with the fire department, with the corporation, all right, the membership corporation. The problem is, again, fire districts don't normally pay money. So we have to come up with a legitimate way that the fire district is going to take money and pay it to the fire department. And it has to be for some service. Well, fine. So it's for providing ambulance service. So let's say we're going to estimate the copayments to be $15,000. We're going to pay $15,000 to the fire district or to the fire department from the fire district. That doesn't mean that the fire department can't then turn back some of those funds right back to the district saying, well, we collected this much, so we're going to pay some of it back to you. As long as you have these transactions very clearly delineated in a contract, you should be okay. So we need to have a very detailed contract that explains what we're doing, how we're doing. The law cites the law that we're doing it under, shows the estimate, how we got to our estimates of what the copayments are, and then explains the arrangements. This is complicated, but ultimately it's the second method of making sure that residents do not pay copayments. Now, in both these instances, let me make clear, non-residents must pay copayments because they're not paying anything in taxes. So method one or method two from non-residents still have to pay the copayments. Now, deductibles are different because this is an insurance obligation. And listen, here's my 2 cents on deductibles. You're not going to waive a deductible, but you can claim hardship. But if you waive part of that deductible, well, presumably they were transported to the hospital, because if you didn't transport them to the hospital, you're probably not billing them or billing them anything significant other than a treat and release, maybe $50, $75. But if they go to the hospital, what do you think the hospital is doing? The hospital is going to charge them the full bill, which is probably a lot more than $1,500. And the deductible is going to be applied either or both to your bill and also to the hospital's bill. So you waiving the deductible for a patient who was transported to the hospital is probably not doing them any favor. They're going to probably end up paying that anyway. So I really want to make clear that this method too is very complicated and really takes a lot of analysis before you make a decision, right? We've got to come up with what is the fire district paying the ambulance service, in other words, the fire department here, for? What services are they providing for? But we can do that, and there are a number of very legitimate services that we could put into a contract as the reason why the fire district is assuming the copayment and paying that money on behalf of the patient. So the contract with the town, when we have a town contract, and this is where I'm talking about a fire department who's located in or contracts with a fire protection district, with the town to serve its fire protection district, this is also just as complicated. So if you're a fire department, what we call independent fire department, and you are not in a fire district and you're not in a village and you're not in a city or a county and you're contracting with the town, here, this is the same exact issue. We're really going to be dealing with method 2, not method 1. Method 1 will work if the town has and holds a municipal CON. Then we could do method 1. If the town doesn't hold a municipal CON and is simply contracting with you and is paying you the ambulance service money, which it might be doing as part of a fire protection contract, then we have to much more easily label some of those fire protection monies as the copayment obligation. So much easier situation when you have a town contracting with the fire department, but still the language is complicated, and I wouldn't be trying this for the first time if you've never drafted this. So that is everything you need to know about copayments and deductibles. Till next time, I'll see you at the next module on Pinsky Law Presents.